Welcome to the Nimbus Consulting Group presentation on Crime Victims Domestic Violence Incident Reports 2. This mandate requires that all domestic violence or DV-related calls for assistance include on the DV Incident Report form a notation of whether the officer who responded to the DV call found it necessary to inquire of the victim, the alleged abuser, or both, whether a firearm or deadly weapon was present at the location. In plain language, it now requires local law enforcement agencies to include firearm information on the domestic violence incident report form. Although pre-existing law required filing an incident report form for all DV cases, pre-existing law did not require the incident report form to include this firearm information. Agencies have the ability to claim almost 8 fiscal years' worth of costs beginning January 1, 2002 through fiscal year 2008-2009. For a timely filing, these claims are due December 7th to the State Controller's Office. For fiscal year 9-10, those claims will be due February 15th, 2011. This is a multi-departmental claim in that the police, city attorney, sheriff, and district attorney are eligible claimants. There are several reimbursable activities which will be discussed further in the following slides. First is to amend the receipt for the confiscating firearm or deadly weapon, inquire of the victim and alleged abuser of the presence of a firearm or deadly weapon, conducting a lawful search, discovering a firearm or deadly weapon, and payment of attorney fees to the prevailing party. Beginning January 1, 2003, there is a one-time only cost to amend the receipt for a confiscated firearm or deadly weapon to include the language, the time limit for recovery as required. Beginning January 1, 2002, for all domestic violence-related calls for assistance, noting on the DV incident form if the officer found it necessary to inquire of the victim, the abuser, or both, whether a firearm or deadly weapon was present, and noting whether the inquiry disclosed presence of a firearm or deadly weapon. Beginning January 1, 2003, the following activities are eligible when a firearm or deadly weapon is discovered during a lawful search. If the firearm or deadly weapon is found during a consensual search or plain sight, you may not claim these activities. Time spent to take temporary custody of a firearm or deadly weapon, time to give the owner a receipt for the firearm, which lists any identification or serial number. It indicates where the firearm or weapon can be recovered, the time limit for recovery, and the date after which the owner or possessor can recover it. In addition, making the firearm or weapon available to the owner or person in lawful possession 48 hours after seizure, but not later than 5 days. This reimbursement activity is not eligible if the firearm or deadly weapon was confiscated and retained as evidence to a criminal charge as a result of domestic violence, and when the firearm or deadly weapon is retained because it was illegally possessed or because of a court petition that was filed. To continue with activities that are reimbursable beginning January 1, 2003, time to sell or destroy a firearm or weapon held longer than 12 months and not recovered by the owner. This is because it's considered a nuisance and local agencies have the ability to sell or destroy the firearm. However, firearms or deadly weapons not recovered within the 12 months due to an extended hearing are not subject to destruction. Within 60 days of the date of seizure, or 90 days if an extension is granted, time spent to initiate a petition in Superior Court that the firearm should not be returned to the owner because it's reasonable to believe that it would likely result in endangering the victim or the person reporting the assault or threat. This is also time spent to notify the owner that they can petition for the firearm or weapon to be returned. This activity is typically performed by the city attorney or the district attorney. And time spent to inform the owner that they have 30 days to respond to the court clerk to confirm the desire for a hearing to obtain their weapon, and that failure to respond results in a default order forfeiting the confiscated firearm or weapon. In this instance, time spent to file a petition in court for an order of default is eligible, and this is time spent by typically the city attorney or district attorney. If the owner requests a hearing, then time spent to show in court by a preponderance of evidence that the return of the firearm or weapon would result in endangering the victim or the person reporting the assault. Again, this is time that would be spent by the city attorney or the district attorney. If the court orders the firearm or the weapon to be returned to the owner, and since the court is required to impose the awarding of attorney's fees, then the local agency is required to pay them. And then in this instance, the attorney fees paid to the prevailing party would be eligible for reimbursement. For the last activity, local agencies can seek reimbursement beginning January 1, 2003, when a firearm or deadly weapon is taken into custody when discovered in plain sight. You're able to recoup the attorney fees paid to the prevailing party. You would claim these costs if the owner petitions the court for a second hearing within 12 months of the date of the initial hearing to have the firearm returned to them, and the court orders that the firearm or deadly weapon be returned to the owner. As to awarding the attorney fees, since the court is required to impose them, the local agency is required to pay them, and therefore you're able to seek reimbursement of reasonable attorney fees paid to the prevailing party. This concludes our presentation on Crime Victims Domestic Violence Incident Reports 2. For more information on Nimbus Consulting and its services, please visit our website at nimbusconsultinggroup.com. For any questions or for more information, feel free to email us at info@nimbusconsultinggroup.com or give us a call.